All right, good evening, everyone, and welcome to the Commission on Police Practices monthly open meeting. I will go ahead and call the October 25th, 2022 meeting of the City of San Diego's Commission on Police Practices to order. I will turn it over to Charmaine Mosley, our Interim Executive Director, for roll call.
Thank you. Chair Halpert.
I'm here.
First Vice Chair Case.
Here.
Commissioner Dent.
Here.
Commissioner Harrington.
Here.
Commissioner Smith.
Here.
Commissioner Clark.
Here.
Commissioner Vaughn.
Present.
Commissioner Darby Griffin. Does she have to hop off?
Oh, she's still here.
Still
I'm
here.
here.
Yep, there we go.
And Commissioner Shea and Spruce, they are both absent or excused from the meeting. Commissioner Pink is absent. What do we have from Internal Affairs?
Yeah, myself, both Lieutenant Sain and Lieutenant Smartlap.
Excellent, and that completes, and also, I'm sorry, we have outside counsel Dwayne Bennett and administrative aide Robin Resendez with us as well. That completes roll call.
All right, thank you. First item up we have, it's our monthly adoption of the resolution authorizing and ratifying the continuance of teleconferencing. So the motion we have that'll be on the table is the Commission on Police Practices will adopt this resolution authorizing and ratifying the use of teleconferencing for all meetings, including a meeting of its ad hoc or standing committees in accordance with Government Code Section 54953E and all other applicable provisions of the Brown Act for a period of 30 days from the adoption of this resolution or such time that the Commission adopts a subsequent resolution in accordance with Government Code Section 54953E. The interim executive director is directed to return no later than 30 days after the adoption of this resolution with an item for this legislative body's reconsideration of these findings. And with that, I'll go ahead and have that motion. Can I get a second officially?
I'll second.
A second by Nancy. And now Charmaine, can you call a vote, please?
First Vice Chair Case.
Yes.
Commissioner Vaughn.
Yes.
Commissioner Dent.
Yes.
Second Vice Chair Harrington.
Yes.
Commissioner Darby Griffin.
Yes.
Commissioner Shea is excused. Commissioner Smith.
Yes.
Commissioner Clark.
Yes.
Commissioner Pink is absent. Chair Halpert.
Vote yes.
Motion passes 801. Actually 800. Sorry about that.
Okay, perfect. Next item up is any public comment. I don't believe we received any through our web form. Charmaine, is that correct?
That is correct. No public comment received.
Okay, and we don't have any attendees here for public comment, but if there's any commissioners who would like to make any public comment, go ahead and raise your hand. All right, and with that, we're scheduled to go into closed session at 4:10. So Dwayne, I'll turn it over to you and you can read us in for public comment.
Oh,
Sorry, for public comment for our upcoming closed session.
okay, Honorable Chair, thank you. There'd be a recommended closed session pursuant to Government Code Section 54957 to discuss complaints complaints that are deemed confidential under Penal Code Sections 832.5 through 832.8. I believe there are several matters to be discussed into those categories. That would be my recommendation.
All right, thank you. And I think because we have on the agenda a time-specific issue, I think we have to sit here for about 5 minutes until we officially go into closed session.
That's correct.
Oh, yeah, I didn't even see you when I was doing the roll call.
I know,
forgot
that's
you
okay.
were here. You should have raised your hand.
I know, I was like, I'm here, but that's okay.
Sorry.
It's okay.
All right, and with that, it is now officially 4:10. So we're going to enter into closed session. And then we will have our report back right about 6 o'clock when we start our continuation of the meeting. All right, welcome everyone to the resumption of our open session meeting of the Commission on Police Practices for October 25th. Apologies for starting a little bit late. Our closed session ran a little bit long. So without further delay, the next item we have is the report out from our closed session. I will turn that over to our outside counsel, Dwayne Bennett.
Okay, thank you, Honorable Chair. The commission met in closed session pursuant to Government Code Section 54-957 to discuss various matters, including police discipline and complaints, protected and deemed confidential under Penal Code Sections 832.5 through 832.8. The commission gave direction, but the commission by a 7-0 vote did authorize an action back to the police department in terms of deviation from the matrix, as the chair can elaborate upon.
Sure, thank you. So we wanted to, or we will be sending a memo to the police department asking that when command does a review, or they do their discipline memo, that if they deviate from the discipline matrix, that they need to elaborate as to exactly why. And then you say what the deviation was and why they're deviating. So as part of that, I'm going to review the policy just to make sure if it's not in there, that we make a recommendation to add it. And if it is in there, we're going to basically remind them we'd like to see those memos reflecting any deviations and why. So with that, and that closes out our report out. The next item, it's the purpose of the Commission on Police Practices. The purpose of the Commission on Police Practices is to provide an independent investigation of officer-involved shootings and in-custody deaths, and an unbiased evaluation of all complaints against the San Diego Police Department and its personnel in a process that will be transparent and accountable to the community. The Commission will also evaluate and review SDPD policies, practices, training, and protocols, and represent the community in making recommendations for changes. The mission of the Commission is to hold law enforcement accountable to the community and to increase community trust in law enforcement, resulting in increased safety for both the community and law enforcement. And then next up on that, we have the approval of our meeting minutes for September the 27th and October the 11th. Do I have any revisions or changes? And if not, can I get a motion to approve?
So move.
Okay, we have a motion by Nancy. Can I get a second?
I'll second it, Kevin.
All right, thank you, Kevin. Charmaine, can you call a vote?
First Vice Chair Case,
Yes.
Commissioner Hall,
Yes.
Commissioner Dent,
Yes.
Commissioner Harrington,
Yes.
Commissioner Darrell Griffin,
Yes.
Commissioner Smith. I think she hasn't logged in yet. Commissioner Clark,
Yes.
thank you. And Chair Alpert.
I'll vote yes.
Commissioner Pink is absent. Motion passes. The vote is 7-0-0.
All right, thank you. And then non-agenda public comment. I don't know if we have some members of the public here. If you guys would like to make any non-agenda public comment, please go ahead and raise your hand. Okay, not seeing any. We'll go ahead and move on into our educational training. So this month we've reached out to the district attorney's office and we asked if they can do a presentation on how they investigate officer-involved shooting incidents. And so with that, we have the DA's chief investigator, Jorge Duran, and the deputy DA, Stephen, and I apologize greatly if I mispronounce your name, Marquardt.
That's good. Great.
Nice. So I will hand it over to you guys to do your presentation. We have roughly about 20 minutes. So I will hand it on over to you guys.
So thank you. Really appreciate the invitation. So We'd like to take this opportunity to kind of share a little bit of what we do over at the DA's office in terms of reviewing officer-involved shooting and custody death and any other allegation of misconduct by police officers that may rise to the level of a criminal charge. So we prepared a small presentation. I'll let Stephen share his screen and start the presentation. But by way of introduction, my name is Jorge Duran. I've been in law enforcement for almost 35 years. I've been with the DA's office for about 5 years. My experience working in investigations, about 12 years working in a homicide unit, working in some cases, homicide cases, officer-involved shootings, and in custody death cases. Stephen?
Thank you, Chief Duran. Thank you very much for having us here. I'm really glad to be here and having the opportunity to share with the Commission how the District Attorney's Office reviews officer-involved shooting incidents. As I was already introduced, my name is Stephen Marquardt. I'm the Assistant Chief in our Special Operations Division. Special Operations handles a lot of very particular types of cases. One of the fields that we focus on are the officer-involved shootings. So all of those incidents are reviewed by the investigators and the attorneys that are within this division. So I am going to share my screen just to give everybody something a little more to look at. And if I can do that, I had it all set up earlier here.
Do I have to make him co-host?
I think
Let me make you a co-host and see what happens.
all right, thank you.
I was gonna say, you should be able to, I think anyone who's a panelist should be able to share your screen.
Yep, I've got it. Here we go. Thank you very much.
Okay.
All right. Let me know if you can see that.
Yes.
We're good, thank you.
Okay. Okay, you can see the full screen version, not the version with the slides on the sides.
You see the version with the slides on the side.
All right. Let me redo that. Sorry for the technical difficulties here.
That's okay. Take your time.
There we go. How's that?
Perfect.
Okay. All right. So the first thing that I wanted to go through is to talk about the fact that for us here at the District Attorney's Office, it is very important that we complete an investigation in a very thorough, independent, and objective manner. When I say that, it is that we recognize how important it is that the public have trust in what we are doing. And for those reasons, we really respect what you are doing on your end as well. We here at the District Attorney's Office have to review every single type of case through an independent lens, applying the law as it applies to those certain circumstances. And it's important that we be objective. So whether this is an officer-involved shooting, a petty theft case, or an assault with a deadly weapon, any sort of incident that our office is reviewing has to be done thoroughly, independently, and objectively. Also, it is very important to us that our process be transparent and be accessible to the public and the media. Obviously, there's a lot of misperception out there that, there's a shroud of mystery whenever it comes to all things law enforcement or prosecution. And of course, we have concerns about confidentiality or protecting the integrity of an investigation. But wherever possible, it is important to us to be transparent and make things accessible. Next, as I said, we want to apply the legal standards that are applicable in every single case, and that goes without exception, and that would include the officer-involved shootings. And to make sure that we are held accountable, that we are holding people accountable, and that we are ensuring public trust, it is very important that there be consistency within the process. So In that vein of things, there was a memorandum of understanding that was signed March 7th of this year. It was signed by 18 major law enforcement offices throughout San Diego County. That included the San Diego Police Department, the District Attorney, that included San Diego Sheriff's Office, the probation officer, and the probation office and many other law enforcement agencies. And it set a framework for which agency will investigate which type of event. For example, as you are probably aware, if under the new memorandum of understanding, if there is a critical incident involving officers employed by San Diego Police Department, it will be San Diego Sheriff's Office that will investigate. And there are all sorts of regulations. This document is one of the central documents that guides us in how we conduct our review. It also takes into account a lot of other things, one of those being AB 1506. AB 1506, I'll touch on a little bit later, but generally it defines what unarmed is. And if somebody is deemed to be unarmed and they die due to an officer-involved shooting, then that is a case that would not be reviewed by the district attorney, but would be reviewed by the state attorney general. This memorandum of understanding also delineates which agency is responsible for media releases and compliance with various government and other codes. It also talks about how a family notification should take place. And all of this is very important because what I want to make clear is when we are doing a legal analysis of anything, structure is critical. And when we are working with our other agencies, structure is critical. And so this is a very methodical approach that we take, both in the manner in which we approach it and also the manner in which we analyze under the law. So getting into our review process, I'm going to turn it over to Chief Duran to talk about what we do when an incident takes place.
All right, thank you, Stephen. So under the protocol for officer-involved shootings and in custody death and any other major incident where law enforcement had to use force or there was a question of force use, our office is notified. We have investigators that are on standby. These are investigators that are experienced in conducting homicide investigations, officer-involved shootings investigations, and they are on standby 24 hours a day, 365 days a year. And whenever there's a officer-involved shooting and custody death or critical incident that may deem that we need to respond, we will respond. So they respond normally within an hour or two to the scene. The district attorney investigator, like I mentioned, is experienced in conducting these types of investigations. They respond to the scene. They basically are there to ensure that the proper investigative steps are taken, the witnesses are separated, the scene is contained, that the investigation follows investigative protocols. The district attorney investigator also sits in on the briefing that the first units that arrived on the scene, where we're typically patrol, they present us a briefing to the homicide investigators who are also there. The DA investigator will participate in that briefing. They may ask questions about certain things that transpired, but they'll get the full gamut of information from the 911 call, the witnesses, and the evidence available. And that information becomes important later on as we receive the reports from the police department, and the investigators will match to make sure that the information is consistent, that the reports reflect what actually happened and what actually transpired during the briefing. In some cases, the deputy DA may, under certain circumstances, attend, the deputy investigator sometimes may attend the autopsy, depending on the circumstances on that case. And in some cases, the investigators will monitor. They will not participate in the interview, but they will monitor certain interviews depending on the nature of the case, just to ensure that the information that we're receiving is accurate and reflected accurately in the reports. Next slide. And then, Steve, you want to take over the 3-day briefing?
Yeah, thank you. In every situation where there is a critical incident, when there is an officer-involved shooting, there is a requirement that a 3-day initial briefing take place. And so the investigating agency whether that's San Diego Police Department, the Sheriff's Office, whoever, they will hold a 3-day briefing. That is, a few days after the incident has taken place. And so a good amount of work has already been put into understanding what took place and why. This is a briefing that includes our office. Oftentimes it will be held here at our office, but sometimes it will be held at the investigating agency's office. Also included in that is the U.S. Attorney's Office Civil Rights Division. The FBI is also included in this 3-day briefing. When it is a San Diego police department case, the San Diego City Attorney's Office will also be involved. And if it is one of those cases involving somebody who is unarmed, who then is deceased, that is a type of case that the state attorney general would take from our office, and then they would also be involved. Now, it's important, again, to see the collaboration here, because there are a lot of different angles. There are a lot of different reasons why these different attendees would want to have an idea very early on in the process of what happened and why. So obviously from a federal level, when there is a possible civil rights violation, that's something that the US government wants to be involved in right away. From the city attorney's office, obviously that is a law office that is representing city employees. And so that's important. The Attorney General's office, they, as I said, under AB 1506, they now do the officer involved shooting incidents where the individual who is shot dies, and where it is determined that that individual is unarmed. The definition of unarmed has shifted a bit since AB 1506 came into place. And when I say shifted, I mean that there's been greater clarification from the Attorney General's office. So for example, if somebody has a replica firearm, but it is not capable of discharging any bullets, and the officer believes that that person is going to shoot a real gun, because of the fact that they have a replica firearm, they are deemed to be unarmed. And so that is a situation where the Attorney General's office might take the case and our office would not conduct the review. Prior to AB 1506 going into effect, our office did review all types of situations. The agreement is that the investigating office, the investigating agency, will deliver all their materials to our office within 90 days. So they should have wrapped up their investigation and then they've provided it to us. In kind, then we have the agreement that we will complete our review within 90 days, but our completion date of 90 days is after we have received all relevant materials. So that can include the ME's report, and it can also include any laboratory findings, whether those are ballistics, those are toxicology reports, or whatever else may need to be analyzed. Currently, there is an extreme backlog at the medical examiner's reports due to the large number of fentanyl-related deaths. And so there has been some delay currently from obtaining the medical examiner's reports. Obviously, we want to have all of the information possible so that we can conduct as thorough and as transparent of an examination of the incident as possible. So that is something that we are currently managing. Once we do have everything, everything is very meticulously reviewed by both a district attorney investigator and a deputy district attorney. As I stated, the deputy district attorneys that review these cases are the specialized attorneys that are in the special operations division. And that goes for the district attorney investigators that are in this division as well. And many of those district attorney investigators have years of experience, many times in homicide divisions in different law enforcement agencies around the county. So they bring with them a wealth of experience. And all of the things that we review are all the things that you would expect, everything that is provided to us by the investigating agency. But in addition to that, we also may at times request supplemental investigation. So we might go back to the investigating agency and ask that they follow up on some points. And there are times when we will conduct additional investigation. If we uncover that there were further witnesses, or if somebody approaches us, then we will take it upon ourselves at that point, potentially to conduct additional investigation. And we're able to do that largely because our district attorney investigators are sworn peace officers within the Bureau of Investigations at the district attorney's office. So that helps with the independent and objective evaluation. Now, we are attorneys here. We are looking at this for criminal liability. So as I stated earlier, with every sort of case that we evaluate at our office, we're evaluating the factual evidence through the lens of a legal standard. So what we have to do is we have to look at what the law says and see what the facts plug into that law and how it computes and if the law has actually been violated. The primary law went into effect in 2020. This is Penal Code Section 835A. And this really lays out when a law officer, when a peace officer may use deadly force. And it also explains the standard that is to be used when evaluating whether or not that use of force was justified. And so I'm going to talk about a little bit about that law, just so that you have an idea of some of the main points that we focus on when we are evaluating all of that vast body of information that we've been given. And to go back to that, when we get this information, the body of work, that the body worn camera footage, the ABLE camera footage, all of the reports, the audio reviews, the toxicology report, the autopsy report, the ballistics, examination reports, all of that, that's evaluated both by the investigator and separately by the attorney. And that way we have multiple perspectives, one with more of that law enforcement perspective, but again, being objective as being part of the district attorney's office now, but also the legal perspective. And that really allows us to do a more thorough job of reviewing all of the evidence and then looking at it under the scope of the law. So what the law does state here is it says that a peace officer is justified in using deadly force upon another person only when the officer reasonably believes, based on the totality of the circumstances, that such force is necessary to defend against an imminent threat of death or serious bodily injury to the officer or to another person. And I know that that is a mouthful, and I put that out there, and I have a few more slides on the law just to show how complex this standard actually is. There are a lot of different moving parts and a lot of things that we have to take into consideration when building this matrix and evaluating what fits where and if the law was violated. So one of the central parts of the law is whether or not there was an imminent threat. And imminent threat is also defined by the law. Imminent threat is defined as when, based on the totality of the circumstances, a reasonable officer in the same situation would believe that the person has the present ability, opportunity, and apparent intent to immediately cause death or serious bodily injury. So again, even a definition of one part of the law has many different parts. So when we evaluate a case, we have to look at what would another reasonable officer in the same situation perceive? Would they perceive that the person that they're confronted with poses an imminent threat of death or serious bodily injury? So you're taking it outside to look at it from the perspective of a reasonable officer. And when we're trying to determine if that threat is imminent, it's not just that interpretation of how you understand imminent. It's defined. It has to be someone who has the present ability to cause death or serious bodily injury. It has to be somebody who has the opportunity at that moment and somebody who has the apparent intent. So the ability, they may have a weapon, the opportunity, they may be unobstructed, or the apparent intent. They may have said something, a threatening, statement or something that gives the impression that they are going to act now. If all of those things are there, and of course, I'm just giving examples, there are an infinite number of possibilities of how these things might interplay, but we need to evaluate whether or not there was actually an imminent threat. If there was not an imminent threat, then it is possible that the use of force would not be justified. The definition also is very clear that a fear of future harm is not considered imminent. So when we're looking at this, it would not be sufficient for someone to say, well, I thought that, if the person got away, then down the line, they might do X, Y, and Z. That would not be considered sufficient under the way that the law was rewritten in 2020. Fear of future harm is never imminent. And when the law went into effect in 2020, we had to adapt, as we are always willing to do, and take the law as it is and apply it as we apply any law. And so that is absolutely what we've done in these types of cases. In fact, our office was the first office after this law was rewritten to charge an officer with homicide based on an unjustified use of deadly force against an individual. This law further goes to state that a peace officer is justified in using deadly force under two circumstances: only when they reasonably believe that there's imminent threat. But under that subsection B, it could also be a situation where the officer needs to apprehend a fleeing person for any felony that threatened or resulted in death or serious bodily injury, if the officer reasonably believes that the person will cause further death or serious bodily injury. So again, there are a lot of clauses within clauses, and so it is a very meticulous and very detailed review. In addition, the law states that when we do conduct these reviews, and after we've looked at all of the evidence, we need to determine whether the deadly force was necessary. And that means that when we're looking at it in terms of what the officer believed, we have to look at it and see if the officer evaluated the situation in light of the particular circumstances. And the law requires that the officer shall use other available resources and techniques if they're reasonably safe and feasible. So what that means is an officer may have a whole host of other equipment on their belt or at their disposal through the use of other officers on scene. But what we need to evaluate is not simply, did the officer also have a taser? Why didn't they simply use a taser? Or did the officer have OC spray? We have to look at what was reasonably safe and feasible to the officer there. And objectively, is that reasonable? So again, more factors within factors. And lastly, the law also lays out that an officer who makes or attempts to make an arrest need not retreat or desist from their efforts because of resistance. So again, an officer still has the right to self-defense. And again, it is fact specific. In every circumstance, we have to evaluate how did things escalate and was there a way to de-escalate, and what decisions were made based on what was there in the present situation. So that is an overview of the very complicated law, but a law that we are all very familiar with in this unit, and a law that we meticulously apply to each and every set of facts that we are confronted with. But there are some other things that I did want to touch on. I know we don't have a lot of time, but I wanted to point out a few other things that are very important to our office. There has been a lot of focus on dealing with individuals who have a mental health history. And there have been numerous incidents where individuals involved in officer-involved shootings had a mental health history, or maybe there was a language or communication barrier. Those are elements that we have to take into consideration in our evaluation. But our office is not just a reactive office, we are also a proactive office. And so there are a lot of things that we would like to do on many fronts that are preventative. And I'm gonna let Chief Duran talk a little bit about some training that our office has taken part in relation to these sort of events.
Oh, thank you, Stephen. So we are, so as a result of being the central depository for all officer-involved shootings, our office generates a study. I think the most recent one is a 25-year study, and that's on our website. And I think many folks have seen that. And basically, we look at the historical facts of different officer-involved shootings over the last 25 years. And some of the factors that come into play that were pretty glaring was that a large percentage of the individuals that were victims of shootings by police officers had either mental health issues or were under the influence of some type of substance abuse, psychoses. So as a result of that, our office engaged with PERT, Psychiatric Emergency Response Team, to produce training for officers and de-escalation and dealing with folks with mental illness. To date, about 4,000 officers in the county have been trained on de-escalation / handling critical incidents, specifically focusing on individuals with mental health concerns and substance abuse issues. Also, we've been working with PERT to provide training to dispatchers, because one of the things that we know from reviewing these cases is that folks that are calling 911 provide a lot of information to the dispatcher. So it's very important for the dispatchers to relay that information to the arriving units, the arriving patrol officers, so they know whether or not the person is suffering from some sort of mental illness, whether the person is armed, information that's going to help the officers at the scene make better decisions in terms of the level of force, if any force needs to be used. Language barriers, communication barriers. We provide feedback to the agencies when we review these cases in terms of what could be done, what could have been done better, or maybe some observations that we made during the review of the investigation that could help the agencies in the future better either train their officers, or at least something that they could take into consideration moving forward. And then again, I talked about the PERT training with the dispatchers and the de-escalation training as well. Our office also provided a 911 card. I don't have a copy here, but it's a card that we provided to all the police departments to have the officers, when they respond to a call regarding an individual that's suffering from mental illness, to provide to the family. It's basically a checklist that the family, when they call 911 as a result of their loved ones being in crisis, that they could provide certain information to the dispatcher. What type of, how will their loved one respond to a uniformed officer when they arrived at the scene? What has worked well to de-escalate the individual that's in crisis when police officers arrive? And then it has a lot of other things on there for family members of individuals that are suffering from mental illness in case there's a crisis, that they could provide that valuable information to the dispatcher, who can translate it to the officers that are responding to their home.
And I just have a couple more slides, and then we'll wrap it up here and open it up for questions if there are questions. Just wanted to show a couple of slides of the numbers of officer-involved shooting incidents that we did review last year in 2021. San Diego Police Department had the most, very slightly. It was pretty evenly spread out, but again, that is a very large jurisdiction. And I think it's also of note that of those officer-involved shootings, many of the individuals were armed with operable firearms. And I point this out because it is a factor. Obviously, as I said, we have to look at the totality of the circumstances, but it is a significant factor when we are considering whether or not someone was justified in doing what they did in response. But again, that is just one factor, and there are many different ways in which a weapon could be used. Oftentimes, our office is reviewing these instances in other units. And when I say that, when an officer-involved shooting takes place, it's oftentimes in the context of another crime that is taking place. And so just as a side note, the Special Operations Division does not review any charges against the suspect or the subject, I should say, the subject individual who has been fired upon. There are times when those individuals have committed crimes, and these are just some examples of times when people have been charged with offenses in non-fatal cases. For us, it is a priority that the family of the individual who has been shot be kept apprised of the process that is happening within our office. So we always make sure that we notify the family that we have received a case, and that is being reviewed by our office so that the family member of an individual, regardless of whether that individual may be prosecuted for something they did or not, we recognize the difficult time that family is going through, and so we do what we can to offer supportive services. And we also want to make sure that the family has a point of contact in the DA's office during the process. Another thing that we do to ensure transparency is after we have completed our review and we generate that letter within 90 days of receiving all of the materials, we post those letters with all of our findings and our analysis online. So those are available to the public. Anybody can go on there right now and look and find an incident and should be able to find our analysis and why we reached the decision that we did after we reviewed all of the materials and applied the legal standards. And as Chief Duran mentioned, we recently completed, actually it was in 2019, we completed a 25-year survey of the officer-involved shootings that our office has looked at countywide. And that also is posted on our website. And so anyone can go back and look at that. It's very extensive, has a lot of graphs and a lot of comparative data. So that's it. I will wrap it up. As I said at the beginning, we try to do a very thorough, independent, and objective review. And I want to state that, you know, I am a member of the community. I am a citizen here, and all of the people that are reviewing these are as well. We all have a common interest in making sure that those who are sworn to protect and serve are upholding their duty and doing that on our behalf and on behalf of all of the citizens of San Diego County and all of the community members that we have. It's very important, I think, that that the public know what we're doing. And that's one of the reasons I am very glad that you guys invited us to do this today, so that people are aware that this is a process that we take very seriously. It is a very meticulous process, a very time-consuming process, but it's also one that's very important, one in which we don't go by which way the heartstrings tug us, or maybe sympathy for one party or another party, but we look at this the same way we look at everything. We apply a legal standard and determine if the law has been violated, the law that we are required to follow. And lastly, again, we want to make sure that people are held accountable, that our office is accountable to the public, and we want to do what we can to build public trust. And a big part of that is the consistency. And so that is where that MOU and making sure that we follow the law in every instance comes into play. So with that, thank you very much for having us. And if there are questions, we're happy to answer them.
All right, thanks very much. Do you want to open it up to our board members for some questions? And I have a couple, but I'm going to let all the commissioners, not board members, go first. So Doug, you're up first.
Okay, thank you very much. That was very informative, and hopefully you'll be able to provide a copy of that PowerPoint to the commission, because there's a lot of useful information in there. I had two questions. One was with regard to the 3-day briefing. As I'm sure you're aware, the commission now has the statutory duty to independently investigate all officer-involved shootings and in custody deaths. So it seems to me that it would be appropriate for our investigator to participate in the 3-day briefing, and I'd like to get a comment on that. And then secondly, you indicated that sometimes the DA's office, after you receive the investigation from the homicide division of the police department or sheriff's department, will sometimes conduct additional investigations. Currently, the commission has unfettered access to the entire case file of the police department and now the sheriff's department. And my question is, will we have unfettered access to the content of the additional investigations, including interviews and reports generated?
Yes, okay, thank you. So as far as your first question goes, the 3-day briefing. The 3-day briefing is something that is outlined in the MOU, in the Memorandum of Understanding that was signed on March 7th, 2022, as part of the protocol to make sure that a consistent process is being followed between the agencies and our office. When that was signed, the commission was not a party to the memorandum of understanding. But I am not going to definitively say that that is something that excludes or includes. But that is a point that is well taken and something that I am happy to take back internally and review your concerns regarding that. On the second point, if our office conducted an interview of an additional witness, or if we had follow-up questions for somebody who had some relevance, or maybe we did further investigation with the medical examiner. If that is something that is relevant to your investigation and you have unfettered access, I would expect that you would be able to receive a copy of that as well. As a lawyer, I am going to put an asterisk with a disclaimer to say that nothing I say is in absolute terms, but what I'm saying is my initial impression from what you're saying is that you are trying to examine this through your lens. And if we want you to be successful, which we absolutely do, then it makes sense that you would have all of the information. I just went through talking about how important transparency is. And so for those purposes, I would expect that that would make sense. There may be some sort of issue that I'm not thinking of right now, but generally I think that that would make sense. So I will also take that back internally and review that, and we can get back to the commission on answers on both of those items. I appreciate you raising both of those very interesting points.
Thank you.
All right, are there any other commissioner questions? Okay, I'm not seeing any. I had a couple that I wrote down. How often does the U.S. Attorney, the U.S. Attorney's Office for civil rights, and then I think the Attorney General, the FBI, how often do they participate in your investigations and ask for more clarification on anything, perhaps for them to further review or investigate on their own?
When you say how often, it's difficult to respond. Everything again is on a case-by-case basis. I can tell you that they do regularly attend that 3-day briefing. What they do internally, I can't speak to. But generally, if there is a matter that we are reviewing, we make our findings public, and they have access to those findings as any member of the public would. They also, as I stated, they're included in a 3-day briefing. So they do have, access to the individuals who have conducted the investigation or are conducting the investigation. And we do have ties with those agencies. So it would be possible for them to call and ask follow-up questions if they wanted to, but how regularly that happens, I don't feel that I can speak to that because not every single case that comes in on an officer-involved shooting incident is one that I am personally managing. So I have had contact with U.S. Attorney's Office before. Obviously, they have vested interest in making sure that civil rights are not being violated. And so when they feel the need, then they will make that decision based on their criteria. But they do know that they can reach out to us and that we will be responsive when possible.
Thanks. And then how often does the DA's office actually do additional investigation beyond what you receive from the investigating agency?
Well, our hope obviously is that every investigation is going to be complete when we receive it. And I would say that generally they are. Oftentimes, if there is the need for something further, it may be something where we will ask the agency if they followed up on something so that they can complete it themselves and complete it in their body of work. So it may be something, and again, I'm just using this as a general example. This is not case specific. Nothing I'm saying here is case specific. But if there is an issue of, ballistics testing or something, you might have body worn camera of a shooting incident. But we may, from a legal perspective, feel like, we want every I dotted or T crossed in a particular situation. And so we may, ask them to make sure that the ballistics testing is as extensive as possible or something along those lines. But for us to actually take something on ourselves and investigate it, I would say that it does not happen very often, because these agencies have this down and generally do a very, very extensive investigation. And that's what we receive.
Okay, I had a couple others, but I know we're running late on time, so I don't want to go too crazy. And I do see we have, unless there's any other commissioners who have any questions or comments. I do see there is a member of the public, Sheila, former commissioner, actually. So Sheila, I will let you go ahead and talk. You've got up to 2 minutes.
Okay, thank you. Can you all hear me?
We can.
Oh, great. Perhaps Chief DA Investigator Duran might be able to answer this one. When officers encounter for example, if there's a fatality with a young adult or an adult with autism or ADD, how is that investigated the same as someone with a mental health issue?
In terms of,
You know how it's investigated, like there's PERT training. You mentioned the officers have so many hours of PERT training with mental health. Do you know offhand how many hours that is? Just offhand.
well, currently we put on an 8-hour course on mental health, responding to critical incidents involving individuals with mental health concerns. But if a person is shot by the police and it turns out that they are suffering from mental health issues,
Yes.
it is investigated the same way.
Okay.
However, we do look at the steps that the officers, under the law, what steps the officers took to mitigate that concern or become aware of that concern. That's why that dispatcher training is so important, because the dispatcher can ask those questions about the person's mental state, capacity, to understand what the officers are asking them to do. So that's taken into consideration during the review of the case in general.
Okay, so that includes, like I mentioned, autism or ADD. Okay.
Yes, ma'am.
Okay. Thank you. That was all. Thank you.
All right, thanks very much. We appreciate all your time and the presentation. And if, as Doug requested, if you guys can share that PowerPoint presentation with us, that would be great. All right, moving on to our next items on the agenda. The next one is unfinished business. Feedback on the triaging of cases. Just a reminder for all of our teams and the public who's watching. What we're trying to do right now is when we have cases that come up for teams to review, we're looking at cases that have sustained findings to make sure that those get pushed to the front of the list. And then we're also asking teams to kind of review cases as they come in, just to make sure that we have everything we need from the police department, and that if there's any other additional findings or requests that we need to make, that we can get those done so we can try to get those cases as quickly as possible. So any questions or comments from anyone on the commission about that? All right, not seeing any. Trying to, yep, go ahead.
I think that we should revisit, I guess we should revisit what the commission agreed upon doing previously as far as writing the case report shorter. Just because, looking at the number of cases that's coming in and the number of cases that's being reviewed, it's not really helping. It's not really affecting that. So
Well, I think, and kind of mostly for the public that's watching as well, part of the,
They have me muted.
hang on, actually, let me mute you for, yeah. There we go. So I think one of the concerns, not concerns, one of the facts is we're getting complaints almost as fast as we're able to resolve them. So for example, today in our closed session, we had 4 cases that were ready to be reviewed. We got through 3 of them. And I believe just in the last 2 days, we've already had 3 additional cases assigned. So even though we're trying to be as efficient and as quick as we can in the review of our cases, just by the sheer numbers, as we've repeatedly, unfortunately said, a full commission until the implementation orders goes through should have 23 members. Right now we're at 11. So we have 11 volunteer commissioners that are trying to get through about 120 cases. So as all volunteers, we already have several people that are doing, And in the past, we used to say it was about 20 hours a month for volunteers. And I would say several of us are probably doing 40, 50, 60 hours a month, which is a lot for volunteers. And so there's only so many things we can do. But I think to Charmaine's point, we need to try to find a way that we can get through the cases by still reviewing them until we get to the new commission that can then decide if they want to do something differently as we go forward. But yeah, the case numbers aren't going down as we hoped, unfortunately.
Thank you.
I don't think I saw any hands go up on that one. So new business. One of the items we had, we can go back to the agenda. Thank you. This had actually come up as a request both from the police department and also a member of the public was asking to reorder our future agendas to basically put the police department's report after non-agenda public comment. So I think there's kind of a two-pronged approach. I think that way members of the public can kind of hear what was going on with the police department earlier, and if they then want to hop off our meeting, they can. And I think also the other side is for the police department, so they don't have to be through the whole meeting. There's pros and cons, I think, to both. I wanted to open up for a discussion item. One of the pros I would say is even though every Thursday after we have our closed session meeting, Charmaine and I as chair typically have a meeting with internal affairs to go over any questions or concerns that we had with the cases that we just reviewed. And then also just bring up any other topics of things that we need to address either on our side from the commission or on the police department side. The flip side of that is I do think having the police department here till the end of our meeting is that way they do get to hear everything that we're trying to work on. They get to hear the report outs from our subcommittees, which I think in several cases, especially policy, directly it involves them or it will impact them. So I think there's a benefit for them being here, but at the same time, we also don't want to force people to sit here for sometimes a 2-hour meeting when maybe they're not getting as much value out of that. So we want to put it up as a discussion item for commissioners to talk about. Are you guys comfortable with moving them after non-agenda public comments? Do you want to keep them where they are? Wanted to open up and see what everyone thought before we made a decision on future agendas. So with that, feel free to speak up or raise your hand if you guys have any comments. All right, we're all speaking at once apparently. So
I think it's a reasonable request. I certainly can see the benefit of having, SCPD on for the duration of the meeting. Sometimes questions come up throughout the meeting and we can refer to them for their expertise. And at the same time, there's also meetings where, they're probably not getting as much value out of those meetings. So I think it's a reasonable request, and I have no problem with moving them up.
Anybody else want to chime in? All right, not seeing up. Charmaine, go ahead.
I would suggest instead of moving them up for non-agenda public comment, that we consider moving them after the committee report. Just because for the policy committee, there's always policy items on there. And most of the time we have for the SDPD's report status updates for their for memos that we send to PD.
I'd be comfortable with that change. I'm not seeing any other hands go up. So there we go. Nancy.
Maybe we should take this under advisement and just revisit the whole agenda and see if there's a better sequence of presenting and discussing information.
Well, I think also just because we move it to one spot on the agenda for the next meeting doesn't mean we can't change it if we find that there's a more effective and efficient way to do it. So
Right.
And then actually, since we have at least a couple members of the department here, do you guys want to chime in? Do you have any thoughts, questions, concerns, requests?
No, Brandon, this is Captain Debris. Yeah, our request would be to move it up. Like you said, most of the times, you guys are talking about stuff that really doesn't pertain to us, but I can also understand you're wanting us to be to the end, but I think a lot of the public does not stay to the end, so they don't get to hear our portion of it. That's my 2 cents.
Okay, thanks. So I think what I'm hearing is, in general, there's consensus that we want to move the department's report further up, and I'm kind of gathering it'll be maybe up to the cabinet to decide where we want to put it. And then we can, I think maybe what makes sense is, to Nancy's point, maybe what we do is we reorder the agenda a little bit. I agree that it might be helpful for the department to be there for at least our policy recommendations, because those are things that will directly impact what we're going to be sending to the department. And I do think it's helpful for them to hear that. But I think also some of the other items, like the new business, when we're just talking about the structural aspects of what the commission does, the department doesn't really have to be here for that. Sorry, that's my dog. So maybe what we'll do is we can look at adding it maybe before new business. And then maybe what we can do is after that, we'll do our committee reports, and then IA and the department can just hop off after we do policy. That way we can try to make it a little more efficient, so you guys don't have to be on here for 2 hours. Doug, you have your hand up, but you're on mute.
Sorry about that. I guess there's 2 separate issues. One is the department giving their report when there still is a large number of the public present. And we can move up their report, and then based upon what the agenda is, you could have discussions with the department, because the second issue is having them be available to consult and also to be able to hear what we are discussing on issues that affect them. And so maybe the report could be earlier, but we could have a discussion with the department as to what part of the agenda they need to be present for afterwards. So.
Okay, well, what I would propose is when we have our cabinet meeting, which is usually on Mondays at 3:30, we can discuss that then. And then for next month's open agenda, we can go ahead and make a change, moving them up. And then as long as the commission trusts the cabinet to put them in the right spot, we can at least do that. We can try it for a month. And then if we want to make some changes, we can always make changes on future months as well. Do we pretty much have, I don't think we have to make a motion on that for agreement, just changing the agenda. But if anyone on the commission disagrees, please speak now or forever hold your peace.
Well, this is just a discussion item anyway.
And then Robin, I saw you raise your hand.
Kevin just hopped off.
So I think we
He's
still
a
have
7.
quorum. I think we had another person show up. So I think let me just double quick. We'll do a check real quick.
We have exactly 7
Yeah, we have 7. So I think we're still good. We had an 8th person show up. So for the public, we have to have at least 7 commissioners here in order to hold our meeting. And we were right at that number, and we had a new person came in and then a person left. So we're still at 7, we're still good. All right, so I think for that first item, we're good. The next item on the agenda was the operational procedure for nominations and selection for commissioners. And I will hand it on over to Doug, who is the chair of our transition committee.
So hold on just a second. I'm scrolling through the agenda to find the
Robin, can you scroll down? Just be all the way towards the end.
okay, I'm just pulling it up on mine so I can see it in larger print. And the first one is the operational procedure for nomination and selection of the permanent commission. Is that correct?
That is correct.
Okay. And part of this is a recommendation that we already acted upon previously, but it was further refined by the Transition Planning Committee a couple of weeks ago. And the ordinance, which by the way passed its second reading last week, indicates that the commission may establish a nominations committee to make nominations to the to the city council, and it refers to it specifically as an operational procedure, and operational procedures require approval by the city council. And so we're recommending that the commission move forward this operational procedure to the city council so we can begin the process of nominating and selecting the permanent commissioners. And it's not that long, and it's important enough, I think it's worthwhile just reading it. The commission shall appoint a nominations committee to be composed of 9 members with 3 current or former commission members and 6 community members to be chosen by the commission. 2 academic professionals who specialize in policing, criminal justice, and/or civil rights, and 4 from the community, nonprofit organizations, or with relevant expertise in various fields, including but not limited to racial identity profiling. And then we added at the committee meeting, at least one of whom is in the 18 to 24 age group, because we thought that it was important if we're going to be making recommendations for youth commissioners that we have a youth representation on the nominating committee. We also added that none of the nominations committee members shall be None of the nominations committee members shall be associated with law enforcement. Then we added that applicants for the commission shall not be eligible to serve on the nominating committee. 2, all applicants must submit an application via the boards and commissions website. The website is listed there. Applicants may submit up to 2 letters of recommendation from individuals or community-based organizations. A supplemental application will be sent to verify that the applicants meet all the criteria specified in the implementation ordinance, and to ask for their age if they are interested in being considered for one of the youth designated seats. 3, applicants must attend an orientation session to explain how the commission operates and time expectations. 4, a nominations committee shall interview all eligible applicants. All applicants will be asked the same questions to be approved by the city's Human Resources Department. Each nominations committee member shall submit a rating sheet, which is similar to how we do with interviews of potential employees. 5, the city shall provide a list of which candidates that reside in the low and moderate income U.S. Census tracts, because as you recall, there are a certain number of seats that are allocated specifically for those census tracts, and that's not on the application. 6, the nominations committee shall recommend 1 person for each of the open seats. And there are 2 youth designated, 9 city council designated, and 5 from low and moderate income U.S. Census tracts, as I just mentioned, and 9 at large. The nominations committee shall take the priority qualifications as indicated in the implementation ordinance for the at-large seats into consideration in making appointments. And there's a whole section of the implementation ordinance that talks about criteria to be looked at. 7, for the initial 2023 appointments, the nominations committee shall determine which are recommended for an initial 1-year seat and which are for 2-year seats, because they'll be staggered for the initial appointments. 8, the nominations committee shall prepare a brief statement of qualifications for each recommended candidate. 9, the nominations committee shall send all of the recommendations to the city council president, along with the application materials for all candidates. 10 is the final selection shall be at the sole discretion of the city council, which is not required to accept a nomination committee recommendations, and that's per the ordinance. And then 11, a background check shall be conducted by the city's personnel department prior to appointment, which is also per the ordinance. And so this procedure assumes therefore that the nominations committee will make recommendations for all the seats, including the city council or the city council district designated seats, and make recommendations to the city council so that everybody goes through the same application process, but recognizes that it is up to the discretion of the city council whether or not they want to accept the recommendations in the nominating committee. So with that, I'll open it up to questions.
Not seeing any questions. Actually, we have a member of the public. All right, Evie, go ahead.
Okay, there was one number, and I'm sorry, it went by rather quickly, and I don't remember what it was. It had something to do of than being told how things operate and the time it's going to take. Do you remember that one, Doug?
Yes, that one of the requirements is that all applicants attend an orientation session, and the orientation session will explain what the role of the commission is and what the time expectations are for being a member of the commission.
Well, that's based on how you guys are doing it. And we don't know how they may come up, and with the investigators doing things and the like, it could be very different from what you're going to tell them.
Well, and that may vary, and this is a procedure which the new commission will implement. So the, if things change, those,
Yeah, but I mean, it may not take the kind of hours. They may come up with another kind of system. I think that orientation to tell them to do it the way you've been doing it doesn't make a lot of sense to me.
Well, that's not what this says, and we're looking at proposed operating procedures that'll make significant changes in that part of the duties of commissioners, and so.
And then I just want to kind of chime in because I think this is something the previous board and the commission has always had struggles with, is we'd have people that are very interested and wanted to serve on the board. And then once they realize how much is involved, they don't always stay on for much more than, a couple months. And then if we end up getting to that same process, even though things will most likely change in the future, if people don't have a proper expectation of the level of volunteer work that's going to need to go into it, we're going to have to start the whole process over again and then replace new commissioners. And that's not effective or efficient for anybody. So I do think having kind of an orientation, I think is helpful. I think it gives anyone who's interested the opportunity to ask questions. How does it work? What do you do? Why do you do it that way? Even propose other ideas. But I think it's important to have people be able to come in and ask questions and learn about what we do, even if it's what we're doing today, because I think it would be unfair to have people come in and then suddenly once they're on being told, oh, by the way, you're expected to do X, when maybe that wasn't what they thought. And especially if once we've gone through the whole process to get them appointed, and then we have to go back and start the whole process. And unfortunately, as many of us know, the city isn't very fast in getting commissioners added. We've been trying to get commissioners added before we even went through the implementation ordinance, and it was a rush to get it done, and we were able to get it done. But even of the, I think it was like 7 commissioners, I think we only have 3 that are still on. So it's really important that I think people understand what they're getting into when they decide that they want to volunteer for the commission.
Yeah, I understand that, Brendan, and that is the way it's being done now. My fear is that by your giving the plan of how you do it, it will make them think that, and they won't have the opportunity to be able to work something out that may actually work out more to their how they see things. I mean, in other words, you're asking them to step into something already planned.
Well,
yeah, but there are several things that are required to be done in the ordinance, and there are several additional duties that the new commission will have that the current commission does not have. And so it'll be important the orientation will be to go over what all the duties are, and the commission, the permanent commission itself can decide how they want to perform those duties, and they may find more time efficient ways of doing it, but it's really important. All the procedure says that all applicants must attend an orientation session to explain how the commission operates and time expectations. And this is intended not just to be for the initial selection next year, but this is intended to be a procedure that will be used for all future selections.
Kate, you have your hand up. Kate, you should be able to unmute yourself if you still want to. There you go.
Yeah, just to add to part of that discussion, but I really had another item, and that is I think what Evie's getting at is that it's important in the orientation session to say, this is kind of what we expect right now based on the way we've been operating. But when there are new commissioners, you guys can certainly change things and maybe reduce the hours by using the investigators better, or just making it clear that and then of course as time moves on things will change. But I think part of the question is discouraging people at the outset by saying, well, currently we're working, we're doing volunteer work 40 to 50 hours a month. So I think that's just part of the orientation. But my other question that I raised in the transition committee, and I would just like to raise again, is how are the members of the nominating committee chosen? If somebody wants to apply to be on the nominating committee, I mean, like, how do they do that? For example, I know a couple people who are interested in being on it, former CRB members, community members. And so how was that process done? Because that's not set out.
Well, and that actually is on the agenda for this week's transition planning committee meeting.
Well, I guess I should have looked at the agenda. Huh?
And, and based on that, well, I think we would leave the, the operating procedure, as it is, but our internal procedure of how we're going to select who's going to be on the nominations committee is a good question. Because it applies not just to the nominating committee, but to the entire, not just to the CPP members, but also to the community organizations and so forth. And so how number one is implemented is an issue that requires discussion. And in fact, that's the first item of discussion on this week's transition planning committee.
Okay. Evie, you have your hand up again, but I want to try, we're going to be running out of time, so I want to try to keep moving forward on this, but I'll let you have a couple seconds. Go ahead.
I just thought maybe there was a good possibility that there wouldn't be somebody on there that was appropriate for some reason or other to fill every one of the 9 seats from the city council. And what would you do then? There may need to be just some consideration, because that's the only thing that's going to stop. That may come up that won't work into your plan. You hear what I'm trying to say is there may not be someone from each of the 9 that you think are appropriate for the committee.
I guess hopefully we will do sufficient outreach and recruitment that we will have sufficient applicants to do that. But in that case, then the nominating committee would make nominations for all those seats and leave those seats vacant to be filled at a subsequent meeting of the city council.
And I think, and I'd have to go back to look to see what finally got done, but I think the idea also was, if after doing everything we could to try to fill those seats, if that seat remained vacant, that we could basically go through the process and try to have that filled by backfilling perhaps another at-large or something like that. But I think the idea is everyone wants to make sure that the commission is able to be effective and hopefully fully seated. And if, for example, we can't get someone from every district, or we can't get someone that fills in for the lower moderate income census tracts, we want to make sure that we can hopefully get all those people seated. So I think, Doug, do you want to?
I was going to say, I think the ordinance requires that the city council appoint all 25 commissioners, and so it'll be up to the commission and the community to do appropriate outreach and recruitment to make sure that we were able to make nominations for all 25 seats.
Yeah. Okay. Kate, I see your hand up. And again, I'm going to try to keep things moving quickly, so I'll give you a couple seconds. Go ahead.
Yeah, well, I think it's important to remember that not necessarily all the commissioners are going to go through this process, that the city council members can appoint on their own. And I suspect that some of the city council members will have somebody that they want to appoint for their designated seat, for example, and people can self-nominate. I mean, there's other ways other than just the nominations committee. So I think if you don't come up with someone, for example, from D6 or some other district, that it's up to their city council member to find somebody.
Yeah, I mean, that's a good point. The one thing I would just say is we've oftentimes worked with city council members to try to find someone from their district, and even with their work trying to get people from their district to be able to be represented on the commission, we still haven't always been able to get those people seated. So we try. Doug, did you want to do any final questions or comments on that before we move on to the executive director selection?
We probably should build them into separately.
Okay. All right, then. Does everyone understand what we're voting on? We're voting on, I can share this so people can see it again. Hang on. All right. So we are voting, whoops, too far. We're voting to approve the draft operational procedure on nominations and selection process. So with that, Charmaine, can you call a vote?
First Vice Chair Case,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Dent,
Yes.
Commissioner. Is Dr. Griffin here?
Yes, she's here.
Dr. Griffin?
Yes, I vote yes.
Thank you. Commissioner Harrington,
He left.
you come back on him. Commissioner Smith,
Yes.
Commissioner Clark,
Yes.
Chair Halpert.
I'll vote yes.
Motion passes 7-0-0.
All right, perfect. The next item up was the appointment and selection process of the executive director.
Okay, and then some background, the executive director selection, the executive director is mentioned in a separate ordinance that was previously passed by the city council. And it does not address the issue of selection other than that the city council shall make the appointment, but that the person still serves at the will and direction of the commission. And so it makes sense that the commission and the community be involved in the selection process. That ordinance doesn't specify that the commission can establish a operating procedure, but it doesn't preclude that. And so we're trying to be proactive by suggesting a process to the city council. And again, the intent is that the executive director search would not proceed until the permanent commission is seated. And so going through this again, number one, the commission shall contract with an executive search firm to conduct a national search. The search firm will prepare a brochure about the position in consultation with the commission and the city's human resources department. The search firm will post the position on the city's website and ACOL and other relevant sites for at least 30 days. Two, the search firm will conduct an independent evaluation of each applicant and select 10 to 15 that appear to be the most qualified. Three, a selection committee consisting of commission officers or their designees and a community representative chosen by the commission will determine 5 to 7 semifinalists. A community panel comprised of representatives from 7 to 10 community organizations will interview the candidates and submit rating sheets. All candidates will be asked the same questions approved by the city's human resources department. All community panel members will be required to sign a confidentiality agreement. 5, the commission will conduct confidential meetings to interview the candidates. Every commissioner will submit a rating sheet. All candidates will be asked the same questions approved by the city's human resources department. So they basically will go through 2 presentations, one to the community panel, one to the commission, entire commission. And then 6, the selection committee will review the rating sheets and select at least 3 candidates to interview. The selection committee will recommend 3 candidates to the city council. Candidates will not be ranked ordered. Instead, the selection committee will submit a list of strengths and weaknesses of each candidate. And 8, the city council will interview the 3 finalists and make the appointment. And so I would so move.
All right, opening up to questions, comments. All right, I'm not seeing any. Let's go for a vote to approve.
First Vice Chair Case,
Yes.
Commissioner Vaughn,
Yes.
Commissioner Dent,
Yes.
Commissioner Dr. Griffin,
Yes.
Commissioner Smith,
Yes.
Commissioner Clark,
Yes.
and Chair Hilbert.
I'll vote yes.
Motion passes 7-0-0.
All right. I don't remember what else was on the agenda. Let me go back up to that real quick. The draft list of CPP procedures. So that was the very last item we had on there. Oops, one more. There you go. So Doug is muted, but
I don't think that was,
There we go.
if you go back to the agenda, that's not an action item. I think, go back to the,
oh, I guess it wasn't. No. Did you want to go over it at all?
I was going to do it during my report on
Okay.
the transition committee.
Okay, fair enough. The other item we had on here was a draft memo regarding canine cases. So this was something that the former CRB had created and sent to the previous chief, Chief Zimmerman. I did make some minor changes, so I can just share this with you, but the idea is we wanted to send it back to the police department so we can get a formal response. So unfortunately, what happened in the past was they had agreed to do it, but it was a verbal agreement. So we wanted to make sure that we had a written agreement now. So the only changes I made were slight style changes from what you saw in this document. So it's redlined. So the red items is just stylistic issues. And I think I added a tiny bit of clarification, just saying that we would get additional training from SDPD subject matter experts. And with that, are there any questions or comments? And if not, I would like to get a motion to approve and we can send this off.
So move.
Oops. Is there a second? Was that Andrea?
Yeah.
Okay, perfect. Charmaine, can you call a vote?
First Vice Chair Case,
Yes,
Commissioner Vaughn,
Yes.
Commissioner Dent,
Yes.
Commissioner Deborah Griffin,
Yes.
Commissioner Smith,
Yes.
Commissioner Clark,
Yes.
and Chair Hilbert.
I'll vote yes.
Motion passes 7-0-0.
Excellent. Finally moving through the agenda quickly now. The next item we have was the CBP Legal Resource Guide. And with that, I will hand it over to our outside counsel, Dwayne Bennett.
Okay, thank you, Honorable Chair, and I can do this real quickly. The CPP Legal Source Guide was created in anticipation of the commission conducting its own investigation and being a full investigatory body. The role of any police legal advisor and your future general counsel will be to work with your investigators to help them understand the law, as the DA talked about today. The legal standards for complaint investigations can oftentimes be different than what the department does from a departmental standpoint. So the Legal Source Guide touches on various categories of complaints in a very, very brief manner. It's not meant to be comprehensive, but it's just meant to be a place for investigators to start. So the source guide touches on searches, for example, searches incident to arrest, Fourth Amendment waivers, welfare searches, the laws of arrest, what is probable cause. The source guide talks about use of force, and it talks about it from the standpoint of what the district attorney talked about this evening. Penal Code Section 835, as well as the preeminent cases, civil cases, for analyzing use of force cases, including Graham versus Connor, which is where we derive our standard for objective reasonableness, Tennessee versus Garner, where we derive our standard for the fleeing felon rule, and not shooting unless there's an imminent threat of safety or a great bodily harm, as well as a case entitled Diorley versus Rutherford, which stated, it's a Ninth Circuit case, which says that prior to an escalated use of force, officers, where feasible, should provide a warning, and only use that degree of force that's necessary. So that category is discussed. There is a category of discussion relative to complaints of discrimination, which often arise in the context of pretext stops and also in the case or in the context of RIPA, the Racial Profiling Act, how those cases are dealt with, as well as issues of selective prosecution. And finally, one of the things that the new CPP is going to have to do is pitches motions and discovery motions. The ordinance requires the investigative reports that you compile now, but in particular, once you start conducting investigations, those investigations are going to be subject to discovery motions from criminal defendants as well as civil litigants. Under the ordinance, the commission itself must manage its own pitches motions when these discovery requests come into the agency. And in most cases, these pitches motions and these discovery motions are going to seek the information that your investigators garner, as well as their investigative findings, witnesses, et cetera, as well as some of the reports that you may do. Well, the legal source guide talks about this whole process, what investigators need to be on the lookout for, and how the agency from a conceptual standpoint, or how the commission from a conceptual standpoint needs to address these pitches motions. So that's just a brief overview. I hope it is a resource. Again, it will have to be updated and expanded as new complaints come in, as different types of complaints come in, as the commission confronts new issues. But it should be, hopefully, it's from my legal analysis, so it's not subject to meet and confer, but it's based upon over 30, almost 39 years of legal practice, particularly that as a police legal advisor. Police legal advisors' primary roles are to help IA and to work with internal affairs investigators. So I draw on that experience in trying to put this manual together for your future investigators.
Excellent. Thanks, Dwayne. I don't know if anyone's had a chance to go through it. It's a lot of information, but it's good information. And we will also put it up on our secured Google Drive for our resources for the commissioners. Next up, let me share the agenda again. All right, committee chair reports. Nancy, continuing education.
I don't have anything to add from what's here. I was really pleased with our presentation tonight. Thank you for arranging that, Charmaine.
Okay, I'll just add a little bit of context. Some of the last items on here, I scheduled a tour with the medical examiner's office, which we did earlier this month. We also invited CLERB to join. So they had several of their investigators that came along with us. And we also had the executive director of our sister organization, CAB. He came as well. The last item we have on there, the Mobile Crisis Response Team, we do have them scheduled for next month. So they're going to talk a little bit about the new service, how it works, and then kind of, the criteria about how they go out and do that. So that's where we are on continuing education. If anyone has any suggestions on other things, please let Charmaine, myself, and Nancy know, and we can try to see if we can get that scheduled up. Outreach, Robin isn't here today, so I don't think we have anything too crazy, but we are working on doing a meeting coming up that will be for outreach and also recruitment. Rules is currently on hold while we're still kind of pending the new full commission, as is our handbook. Policy, so we did have a policy committee meeting earlier this month. There were several things we went over. A lot of them were kind of informational. Some of the things we were going to make recommendations on, we ended up not needing to because the department agreed to do them. So we went over what was kind of what we call the protest procedure. The department calls it the First Amendment. I'm going to get it wrong because I don't have it in front of me. First Amendment response, I think. So the department did update that. A lot of the changes we've asked for have been incorporated. So we really didn't have anything to add when we went over that in our policy committee meeting. I think a lot of the things that they did do were based on how California law has changed since they first released that procedure. But in general, I think everyone on the policy committee felt pretty good about how that policy is, or that procedure rather, has been crafted. The next item was we were asking to get notification from the police department of policy or procedural changes at the same time the officers are notified. We were going to make that official recommendation, but when we had our meeting with the chief, he basically, the chief and the executive assistant chief both said, yep, no problem. We'll do that. So we'll start getting those. We won't be making a recommendation on that. The use of force procedure, we wanted to add a time requirement for when a use of force requirement or report must be completed. We had a case where an officer basically only did their use of force report after they looked at their body camera, after they were told that someone had filed a complaint. And so we just kind of wanted to possibly make a recommendation on making some changes there. In our conversation with the department, we realized there is some valid reasons as to why that may not be there, but we want to do a little more research first before we move forward on that one. Discipline memos. One of the things that I was looking at and kind of heard from NACOL about some other organizations, what they're doing, was that whenever we get our discipline memo, it lists if it's, the first, second, or third time an officer has had similar misconduct. So say, for example, a body camera violation, this is the first, second time it's happened. But what they often do is if an officer has various accolades or commendations from supervisors, they'll list all of those. So initially I was saying, since you don't tell us all the other bad stuff an officer has done, that you should leave out all the good stuff. And when we had that conversation with the chief, they brought up a very valid point, is if an officer's command goes above or below the discipline matrix, they need to kind of explain why they're doing that. And so if there have been several accolades or accommodations, that could explain why command went a little bit lower on the discipline matrix. So there is kind of a valid reason. So I think because of that, we're probably just going to shelve that. It does make sense. Critical incident video. So for example, when there's an officer involved shooting, the department will release video to the media and to the public. One of the things that we had kind of heard, and I was going to bring up at the NACOL conference, was they wanted to make sure that the family of someone who was involved in an officer involved shooting, that the family was notified and the BWC was shared with them prior to that being released to the public. And we were actually told that the department is already doing that today. So we didn't need to make a response there or a recommendation there. And then finally, the mobile crisis response team, it brought up from a previous case we had of how are referrals made. So say, for example, the department shows up for something and they want to refer that back out to the mobile crisis response for perhaps later follow-up. How does that work? So we put that on hold until we have them come next month and give us their presentation. But those were the things that the policy committee was working on. Kevin's not here, but the recruitment and training, we're going to be working on doing a joint committee meeting with outreach. That's currently scheduled for the 17th at 5:30 p.m. The idea there is to talk about what we need to do to try to recruit new commissioners, going over what Doug had shared a little bit earlier of kind of what the expectations are. And then also I've been working on doing a media marketing plan so we can try to make sure that we get the word out to all of San Diego, city of San Diego, that we're looking for commissioners and get people interested, and hopefully they can submit their interest on the board's and commission's website. The Citizens Advisory Board on police community relations. I actually did not have a chance to watch that video. The agenda is online and I can share that if anyone wants it. And then I promise I will review that before we have our next meeting. If there's anything that's important to share and report out that impacts CPP or the police department, I will share that. But unfortunately, I got busy and I did not have a chance to do that. And then Transition Planning Committee, Doug.
Okay, so let me go back up to the other item that was mentioned previously, and that is the list of operating procedures. For those of you who took the time to read meticulously through all 35 pages of the implementation ordinance, you'll discover that there are numerous places in the ordinance where it says that the commission shall develop operating procedures that shall do 1, 2, 3. And we went through it and we identified 18 different procedures that will have to be adopted by the new commission, and all those operating procedures will require the approval of the city council. We had initially envisioned that we would be able to move forward with the investigation procedures immediately after we had the implementation ordinance, and we already have a draft of the proposed investigation procedures developed. We spent quite a bit of time this past few months doing that. But in looking at the ordinance makes it clear that all of the operating procedures, except for the 2 that we just voted on tonight, cannot move forward until we have a new commission seated, because the ordinance says that the permanent commission shall propose these operating procedures, which means that the commission can't propose the investigation procedures until the new commission is seated, and then that'll require that it go through the meet and confer prior to being able to begin investigations. We were hoping that we could do that concurrently with the selection, but the ordinance basically says we have to wait. It is our intent to propose that procedures for consideration by the new commission. Like I said, we already have the investigation procedures doing, so they don't have to start from scratch on that. And we've identified people in some cases, members of the committee, sometimes in some cases, members of the staff who will be responsible for drafting the procedures to recommend to the new commissioner. And there'll be some that we can simply hold off until the new commission is appointed before they begin working on them. We want to make sure that we are able for the new commission to move forward as expeditiously as possible by having proposed procedures for them to work from, and then they can, revise or modify those at their discretion. And so the list of those is included with the agenda. I see it's up on the screen. Like I said, there's 18 of them, and I'm not going to go through them, but you can go through them to see what they are. So there's a lot of work that has to be done still for full implementation of the commission. And then going back to the agenda, staffing, we are in the process of 2 searches right now. The first search is for the community engagement coordinator. The selection committee, which basically is the transition committee, met this past week, yesterday, and selected the candidates to move forward to the community panel. And the community panel will be meeting, I think, starting next week or shortly thereafter, to conduct the interviews and provide the feedback on those candidates. And we also were in the process of hiring our supervising investigator, and that application period is closed. The executive search consultant is reviewing those right now, and we'll be making recommendations to the selection committee. So we'll be meeting soon on that one as well. A budget update, nothing. Well, I think since the last meeting, which was in September, each of the city council members indicated what their budget priorities are. Those budget memos were due a little bit earlier this year than they had been in the past. I think 3 of the city council members, maybe it was 4, specifically mentioned the commission on police practices is one of their priorities, but we don't anticipate, that, I guess we do anticipate that we'll get support of the city council for our budget moving forward, and there are only minor modifications from last year's proposal that will be proposed this year. I already mentioned that the implementation ordinance and our interim standard operating procedure were approved by the city council on the second reading last week, last Tuesday. And so the implementation ordinance will actually be in effect 30 days after that. So that would be on, I think, November the 17th. It'll officially be in effect, but some things can't move forward until the operating procedures are developed and approved by the city council, as I previously mentioned. And then the fourth one is our office space update, and I'll let Brandon give that update.
Sure, yeah, so the space that we initially had thought we were going to move into, the landlord didn't want to spend any additional tenant improvements on the space, so that would have required us to spend the money on there to make those. Sorry. Anyway, so they did have a kind of a workaround. There's a couple other spaces within the same building. One of them, they have a tenant that wanted to release some of their space. So we looked at that area. It's actually a little bit bigger than we need, but the space will actually work out quite well. So earlier this week, we got some information back from their architects of how to make some changes to try to fit our needs. That looks good to us. And so we've actually sent it back to the city's real estate team, Dream. And so we're now just waiting to hear back from the landlord and their broker. But I think the best case scenario now, I believe, is a December move-in. So it keeps getting pushed back. I think actually it's probably more like January. But the space, I think, will be quite nice. And that's it. Doug, did you have anything else? You all good?
Nope, that's it.
Okay. Chair's report. As I always try to remind everyone, please try to make sure that you get your volunteer hours in. I know when we're doing our annual reports, we try to put how many volunteer hours we put forth. And I think it's really important that we all get credit for the amount of time that we put in to help make the city and the community a better place. So please try to make sure you got those. If for some reason you have a problem logging in, let Alina or Robin know, and we can help get you guys your passwords reset. I don't think many of us, other than I believe Nancy, are actually going into IA on a regular basis. But if we do go in, please definitely make sure you give them advance notice, so we're not just randomly showing up and surprising them. And especially on the weekends, if for some reason something changes and you have to cancel, also please try to give them enough time so they can pull their staff off, because their staff is going to be working overtime to be able to facilitate our needs. I was not able to attend the last statewide organization meeting, but they are working on doing several. Usually it's every quarter they'll have a meeting, and they're trying to do various educational topics, and they're rotating around various attendees. So as I think I said in one of our previous meetings, they've actually asked if we ever have any topics down here in San Diego or San Diego County that we want to present on a statewide kind of audience of oversight groups, that we can let them know and we can get that scheduled in. So I'm sure at some point we'll probably be doing that. The next steps on the countywide MOU between the county chiefs and the sheriff's association, or sorry, the sheriff rather. We were looking at trying to set up a meeting with the sheriff to try to go over some of our concerns. We're trying to figure out if we really need to do an MOU specifically with them, and then what our next steps are going to be on that. So I think our next steps are really just setting up that meeting with the current sheriff, and then we'll figure out how to make a plan going forward. As I said a little bit earlier, we did have our meeting. We try to meet every 2 to 3 months with the chief of police to kind of go over any concerns we've had and kind of high level items. So we did have that meeting earlier this month. I thought actually it was a little longer than normal, but it was quite good. I think we went over a lot of different topics. As I said, in the policy piece, there were several things that we brought up, and even there at the meeting, they just said, yeah, you're right, we'll get that done. So I thought it was a positive meeting. I think in the past we've had some meetings that are a little bit contentious, but this one I think went pretty well. And obviously we don't always agree on everything, but I think we're trying to make sure we can all move forward so we can make sure that the oversight continues in San Diego without any issues. And that's all I have for chair report. I'll hand over to you, Charmaine, executive director report.
Sure. Before I begin my report on case statistics, I'm going to turn over to Robin Resendez, who is our complaints coordinator, for her to provide an update as to the complaints that's coming into our office. I know I've been meaning to do this for a long time. So Robin, can you provide a brief update on those?
Yes, sure, no problem. Thank you, Charmaine. Since the beginning, can you guys hear me?
Yes.
Okay, thank you. Since the beginning of this fiscal year, we received 44 out of jurisdiction cases. I am currently working on categorizing them based on referral to other police agencies. So for example, if I need to refer them to Oceanside, National City, I need to keep record of that. This is also based on the ordinance. So I want to keep that data up to date, and also just for our records. Within our jurisdiction, CPP has received 83 complaints since the beginning of July. I am working together with IA to streamline our process of complaints. For example, how are they classified and how to determine that the complaint is a duplicate. We also received 28 voice messages that I responded to within the fiscal year up to date. About 5% is no voicemail. It's like a blank call. The rest is actual complaints and referring to our website and then going to the proper protocols to process their complaints. I think that's about it regarding complaints.
Okay. So there's a difference between complaints and cases. Not all complaints turn into cases that's investigated by internal affairs. So we need to, that's why we have 2 separate processes. That's important. So I'll just start going over my stats. As of today, we started out with 135 total cases assigned to our teams. This number increased by 15 since last month's open session meeting. So 42 of those cases are category 2 cases. And as we know, the audits of these category 2 cases have been suspended by the commission since several months ago. So although the commission is deliberating on and closing out cases, the number of active cases is continuing to increase, which is what I mentioned earlier at tonight's meeting. Last month, we had 81 active cases assigned to the teams, and as of today, we have 93 active cases assigned to the teams. So also a reminder for the teams to check your discipline and student review board report folders as well in the Google Drive. For this fiscal year, 2023, that began on July 1st, the commission reviewed, deliberated on, and closed out a total of 30 Category 1 cases, 1 officer-involved shooting case, and audited 2 Category 2 cases. The 30 Category 2 cases had a total of 154 allegations and 13 other findings. The commission also evaluated 8 disciplines and 1 shooting review board report. So please note that these statistics does not include the cases reviewed at tonight's meeting that we closed out earlier. So for each team, I think because of time, I'm not going to go over these. So please look at your spreadsheets and let me know if there's any revisions that we need to make. I'll just put these into our meeting minutes just because of time's sake. So next item is the planning of the CPP's member appreciation acknowledgements. That is still on hold just because we're still looking at office space and that has not been finalized yet. Robert, I know I have your name next to this item, so we're just going to keep this on hold until we get some concrete information. Item C is the routing of the routing of items for docket into City Council. So the first item, which is the amended conflict of interest code for CPPs, which is the Form 700 that we are all familiar with. That item was approved by council on October 11th. And the second item is the exemption of 2 program coordinator positions for CPP. Item is on the agenda for the November 1st meeting for council for them to consider and approve that item as well. Item D is a virtual conference and upcoming webinars. So the NACOL virtual conference starts tomorrow. Hopefully, those individuals that are attending have the links. There's been a big delay with us getting our links. Hopefully y'all have the links by now. Virtual conference is going to continue for each, I believe every Wednesday for the next 2 to 3 weeks, and it will end on November 9th. The next item is the preparation of the open data portal, the statistics for the open data portal. So I do have a plan to check into each case and make sure that the data that's in each case is accurate for fiscal year 2022 and release that to the performance and analytics department within the city for them to put up onto the open data portal. So that's something I am working on as well. And the other item that is on my list of things to do is the standardized annual report. So that's going to be next after the open data portal. Lastly is this is something that I meant to add to the agenda and remember last minute. So we were informed by outside counsel and internal affairs that based on state law, there must be a perjury statement that's included on our joint complaint form that we have with SDPD. And that's for complainants to sign in order to file a complaint. This is a requirement that we have to add to the complaint form. And it's going to require that we request, or Robin, when she receives the complaints via email, or if somebody calls in a complaint, that they have to sign this perjury statement. And in order for their complaint to be processed. And Dwayne, I don't know if you can help me as to the state law that requires it.
If I can, Charmaine, Penal Code Section 148.6 is recently litigated by the Los Angeles Police Department, and the court affirmed the fact that that statement must be there. And it's basically a statement that indicates where a complainant has to sign and attest to the fact that this is not a frivolous complaint, that they're not lying about it in essence, and that it is a bona fide complaint. It's been in state law for a long time. Some departments use it, some departments have not, but the LAPD, Police Protective League just litigated it. Case came down in May and the court said you must put it in there. So it needs to be in the citizen complaint forms.
Thank you, Dwayne. So we will be making that change, and I know, Robin, it's going to be difficult, but we're just going to have to work together. Those complainants who are filing complaints via email, we're just going to have to respond to them, hopefully have them, resubmit their complaint electronically, and then sign the form electronically. So that's something we work on doing as soon as possible. And that completes my report. So I don't know if anyone has any questions for me. I
Not
got
seeing any hands up. I was
You
trying
do
to
in your
actually,
spare time.
We have 1 minute.
I was gonna say, I'll just show this really quick. I can share what the updated form looks like on the city's police department website. So basically it's this law enforcement agency chunk based on what the code says. So that's what's required by law to be added to the complaint forms. So this is already on the city's, the police department's complaint form.
Great. Thank you,
All
Jim, real quick.
All right, with that, I don't see Executive Assistant Chief McGrath here, but I see several people from IA. So do one of you want to give a police department report?
Yeah, Brandon, we don't have anything. Yes, Executive Assistant Chief McGrath is off this week, but nothing to report on our side. Thank you.
Okay, are there any commissioner ride-alongs you want to report out on? All right, not seeing any hands. Are there any final commissioner announcements or comments? Nancy, go ahead.
My comment is when we have a meeting for closed meeting and it's supposed to be over at 5:30, please start making sure it gets over at 5:30. I can't do a meeting that starts at 4 and goes until 8. So I really need that break in the middle. So please, can we do that?
Sure thing. Any other final comments? Announcements? Nancy, that wasn't really an announcement, but I got your point. I'm hungry too, so.
It's a comment. It's more than being hungry.
Maybe we can have staff deliver food to all of us.
That'd be nice.
Uh-huh.
It
It would have to be Nancy's pastries.
Yes.
All
We
right,
can
well.
do without food, Doug. That's not the problem.
All right, well, we're now at 8 o'clock, so I think we're officially, and now we're talking about food. So it's time to adjourn. Thanks everyone for your time. Have a good evening and appreciate your time tonight.
Thank you, everyone.
Good night, everybody.
Okay.
Good night.